Welcome in our last day in this first substantive session. Today is we're going to continue our discussion for work stream 3 for dispute prevention and resolution, co-led by Marlene from Jamaica and Michael from Germany. We're going to just resume what we started yesterday, and today I think Marlene and Michael are coming with good slides with some good questions that will trigger the discussion in the room. I will stop here and hand over to Marlene. Please go ahead.
Thank you very much, Rami, and good morning. Good morning, colleagues. First, I want to just thank you so much for the very constructive and engaging discussions that we had yesterday. We feel that the work stream will be enriched by many of the points that you raised, and we look forward to discussing these as we head to Nairobi in November. We thought that we would use the time this morning to address some of the issues that are in the issues note, but that were not discussed yesterday. But we really would love your input on these issues. And for your ease of reference, there are 3 issues that we're going to be looking at. The fact-finding tools, which really has to do with the issue of information asymmetry, because that is part of the issue that leads to disputes. Sometimes it is the taxpayer who has all the information relating to his transaction. Sometimes it's another tax authority that has all the information, and particularly for developing countries that may not have that access, that can also lead to disputes. And so we wanted to address that this morning, and you will see there on the slide a question that we're asking you to address your minds to. For your ease of reference, you will find in the issues note paragraph 7 and 16, which addresses this issue of the fact-finding tools and information asymmetry. So what we want your thoughts on are: what fact-finding tools or procedures do your authorities find most effective? Are there differences in availability or use between different legal systems, for example, common law and civil law, that should be considered? And in your jurisdiction, are you able to take depositions of witnesses, for example, and affidavits? So we are opening the floor for comments, inputs on this particular issue.
Have you mentioned that everything that has been discussed yesterday can also be talked about today?
And just to also mention that you're not precluded from raising issues that were discussed yesterday as well. Russian Federation.
Да. Добрый день. Спасибо за предоставленное слово. С точки зрения применения API-процедур, я хотел бы поделиться нашей практикой и применением практикой ТЦО. Основными источниками информации, которые мы используем, это данные о рентабельности компаний, как российских, так и иностранных, так и данные о стоимости сырья, стоимости commodities. И в этом смысле очень важно, чтобы налоговая администрация имела доступ к публично используемым источникам информации о ценах, о биржевых котировках, которые используются в рамках трансферного ценообразования, чтобы она имела доступ к коммерческим базам, которые также используют налогоплательщики. Я не буду их называть, они довольно широко известны в трансферном ценообразовании. И точно так же, чтобы она имела доступ к коммерческим базам, которые содержат данные о рентабельности иностранных компаний, с которыми производится анализ сопоставимости. Это некий минимальный набор, который обеспечивает эффективность процедур в рамках трансфер-прайсинга. И очень важно, чтобы у администрации действительно был доступ, у каждой администрации был доступ к этому набору информации. Не всегда это возможно, если это иностранные источники или иностранные коммерческие базы. Как правило, налогоплательщики все равно более осведомлены, конечно, о спецификах, об отраслевой специфике, которой они занимаются. И часто, не всегда, конечно, у налоговой администрации есть возможность так погрузиться, не знаю, в аспекты переработки, в аспекты добычи на шельфе, например, в аспекты оказания сервисных услуг. Здесь налогоплательщики всегда в некотором смысле нас опережают, потому что это их бизнес. У нас много таких дел одновременно в разных отраслях, и поэтому здесь хорошо бы обеспечивать некое здесь добросовестное поведение со стороны налогоплательщика, так, чтобы эта информация об отраслевых особенностях ведения бизнеса доставлялась до налоговой службы своевременно в ходе рассмотрения споров. Ну и, конечно, важен обмен информацией между налоговыми администрациями, эффективный в рамках EPA, потому что там решающее значение, конечно, имеет понимание позиции другого налогового органа, иностранного налогового органа в отношении заключения о бенчмарка рентабельности, бенчмарка сырьевых товаров и так далее. Это вот кратко, исходя из нашей практики трансферного ценообразования в России. Надеюсь, это немного помогло. Спасибо.
Thank you, Russia. Indeed, it has. Michael?
Good morning, dear colleagues, distinguished delegates. Thank you very much, Russia, for the intervention. We have a couple of questions in our sleeves for today's morning, as Marlene said at the beginning, so we wanted to take them one by one. However, given Russia's intervention, so we would like to pick up on something that was mentioned, and it is, I think, related to comparable databases. So, Katie, if you could, I would kindly ask you to move to the next slide. Yes. So, of course, we cannot present two slides in parallel. So, I don't know, technically, maybe. Maybe let's have a look also on kind of the next question, because it is very related, and this could prompt more interventions or more considerations coming from the floor. So it is about comparable databases, and this is also a topic that have been addressed in the issues note. In paragraph 11, thank you, Marlene. It is quite frequently was said that member states, tax administrations struggle with the access to databases on comparables, which are particularly relevant when it comes to transfer pricing cases. So we have listened to voices saying that those databases do not contain relevant transactions because they are, for example, not relevant in a particular region, or they are outdated, or they are simply not comparable. And then there's a more general issue that had been mentioned is kind of simply the mere fact that those databases are often only accessible when one subscribes to it, and it is very costly and comes with fees. So Well, I do not have to read out the slide. I'm pretty sure you can read yourself. So I was trying to reflect on what is actually, what had been discussed as an issue. But the question we have put here on the slide is, what challenges does your jurisdiction face in accessing and using transfer pricing comparable databases? I've just mentioned some of those challenges that you might encounter. And if a shared or cooperative database were considered under the protocol, what safeguards would be essential to ensure taxpayer confidentiality? Well, yesterday I said that let's focus on identifying issues for the time being, because we will move on following today's session to the stage of identifying solutions and ideas how to address those issues. We cannot distinguish both phenomena or both categories so clearly. So it would definitely be helpful for us to get a better understanding of where the issues are. And maybe you can consider this in parallel with the previous slide on fact-finding tools. So it is about gathering information or getting access to information. Something that is maybe not specifically addressed in both slides is eventually those information also need to be assessed. So it is maybe getting access to information, but also having efficient means to process information and evaluating the data. I stop here. The floor is open. The floor is open for Mauritius. Mauritius, please.
Thank you, Chair. Good morning to everybody. I think this is an extremely relevant, pertinent, and practical issue there. Being myself a lawyer, a senior counsel that has appeared before courts and arbitral tribunals, either in transfer pricing cases or international arbitration as a lawyer, I can understand the challenges that can practically arise from a technical legal standpoint. One of the former slides there on the left, which is about the differences from civil and common law systems, which I will call clash of legal systems. Mauritius is one of those few countries in the world that has a hybrid legal system, which has both a legal system which is civil and common law. And this has been there for centuries, also because of our historical colonial past. And therefore, clearly, issues like admissibility of evidence before a court of law is not the same whether we're before a common law court or a civil law court. So this is definitely an important point, because what might be admissible before a continental civil legal system could be an issue of multiple hearsay before an English Anglo-Saxon system, and therefore be inadmissible in law. So how do we overcome that sort of technical barrier in the issue of admissibility of evidence, because if evidence is not admissible, well, you do not move forward before a judge. So this is something which I think is extremely relevant for us to look into. The other thing is, besides the clash of systems, is one I would call the clash of languages as well. Being also part of mutual assistance treaties, so many of them, one of the things is going through note verbal and through the Ministry of Foreign Affairs, with another layer which therefore delays exchange of information. Sensitive information for multinationals would even include getting that information using institutions like financial intelligence units, whether investigative or administrative. I think that also is something which is very practical there. And as a lawyer practicing in that field, I can see the difficulties that arise. Now, when it comes to the database, this is extremely interesting because I think put a new number of questions further. Today, who gathers such information as we speak? Where are these data banks kept? I would like to name companies, law firms, or accounting firms. So how do we onboard these to get these details? And of course, as the co-chair, co-leaders pointed out, there's a subscription. And having conducted transfer pricing cases myself, it's extremely difficult to actually access those from a developing country perspective. And the thing is, multinationals are extremely powerful, are very financially strong, and the question is, this asymmetry we've been referring to is that they have access to it, and the authority has more difficulties in getting access to that information. So where and how to get that information from and how to onboard those actors that hold such information. So these are my thoughts on this from a very practical standpoint, because this is what we're talking about this morning. Thank you.
Thank you very much, Mauritius, for flagging those, I think, important issues. And indeed, we already mentioned yesterday that speaking about asymmetry, it is not merely the asymmetry between administrations, tax administrations, but also the asymmetry between the taxpayer on the one side and the administration or administrations on the other side. Thanks for sharing your insights with us. The floor goes now to Austria. Is it Austria or Australia? Austria, please. Sorry.
Thank you, co-lead. Yeah, it's a usual request I get frequently. Speaking from my perspective, I cannot comment on the first slide. I'm not a tax audit specialist, but if you would like to take these questions further, I think we can get more input and then also deliver it during the upcoming work streams meetings, so open to provide more information there. When it comes to the question of comparables database, here I do have experience already, and this is actually this lack of comparables in certain regions across the globe for the purpose of conducting transfer pricing studies. This is, of course, not a new issue. So this has come up a couple of years already, and I think we have been doing quite substantial work in that area in a different forum outside of the UN. Nevertheless, I think extremely valid and constructive work that was carried out with a lot of input from African countries also. I'm talking about the work on Amount B in the inclusive framework. And I think we were listening very closely, especially ATAF has been a very good negotiating partner there, where we did take on board the concerns and problems from African countries. So And I think it was supported across the board from participating member states, because we all think it was a very good idea to do that and to work on that problem. What I want to underscore here is that this is a good idea, and we can work with this, let's say, the pilot project that we have already carried out. At the same time, this pilot project, amount B, of course, only is applicable to a certain set of transfer pricing transactions, or intercompany transactions. But it was also, in my opinion, always a starting point to see if it flies. And I think currently, coming from a developed country, we're a little bit surprised to see that hardly any developing countries are picking it up. So I think here we could also do some more investigation as to why it is, because it was mainly a solution for developing countries. Yeah, happy to work further on this. Thanks.
Thank you very much, Austria. The floor goes now to China.
Thank you, Chair. Regarding the comparable database, we'd like to share some thoughts from us, our experience from us. So in China, in terms of transfer pricing issues, no matter upon advanced pricing arrangement or on MIP cases, we always use commercial database. So we don't have too many difficulties for the access to the database. However, the problem is always how to confirm what comparables are the most suitable ones. As we know that there are no companies which are totally the same or totally comparable, right? But before we talk about this issue, we think that one of the most important problem before this is that we need to discuss on the basis of the same platform or on the basis of the same database upon the settlement of BAPA or APA or MAP cases. That's more important. Without the same platform, we cannot communicate or we cannot negotiate upon the settlement of the cases. That's what we want to share first. Thank you.
Distinguished delegate from China, do you allow me a follow-up question? So what? Pardon. What is lacking is a fora in which a common understanding of communication can take place, or is it the technical means? So maybe I just didn't get it for sure. Thank you.
Okay, I can clarify it further. I mean that maybe to be specific, we need to discuss or communicate on the basis of the same data, maybe database, not a platform. Okay, thank you.
Thanks to you, understood. So the floor goes now to Algeria. Algeria, please. It's okay.
Thank you, Colin, and good morning, dear colleagues. Maybe I'll be stating the obvious here, but the main problem maybe here is that we're having the taxpayer who is declaring, and we're having the fiscal administration, the tax administration, that has the charge to prove. And in proving, here comes the vital role of information. If you don't have information and if you don't have access to databases, or if you don't have enough information, you couldn't make your point. As for developing countries that we are, the problem is access to this information. So we are between the lack of information we are having and the very long time of getting responses when we are trying to get information, and the heavy cost of accessing to commercial databases. That's why, as a developing country, it's vital to have this shared databases public that could allow us have more information in the disposal of the tax administrations, so that they can be more effective in that. Of course, in this shared databases, one of the questions you've put is the way to safeguard the taxpayer confidentiality. This is a point that should be thought about and discussed, but it doesn't need to or it doesn't have to prevent us from developing a public databases. Thank you.
Thank you, Algeria. The floor is now open for Sweden. Sweden, please.
Thank you, Chair. Yeah, I guess this is a crucial question to be able to tax transfer pricing transactions, to have access to the data. And it's a very tricky question as well. I'm not sure if the suggestion is that the UN should develop a database by itself, or whether the UN should use, in one way or another, the databases that are already out there, which are commercial and which are, of course, very expensive. And I would also underscore that it's, having been also involved in the work that the distinguished delegate from Austria referred to earlier. I mean, it's not an easy task. I mean, to build up, I guess, such a database. It's not even, it's a very complicated task as well to use databases already there and to take the information from there. So I think that, I mean, we really need a really thorough discussion on things like, I mean, to get the data and the databases that can be used. I mean, they are databases in developed countries already. So in the project on the Mount B, that was accepted to use those data also in developing countries. But also, I also wonder why that project sort of haven't moved further on the Mount B in developing countries, because that was supposed to be the aim. So I guess that would be at least my first question, what you really mean by building up a database, what the time perspective of that would be, how on earth would you get the data, yeah, and so on. So, and if so, is it okay to use the databases already out there with data from developed countries in developing countries? And to know that, I guess that most delegates here can't answer that. I guess you have to go back to your administration and ask, I mean, taking into account the experience from what was done on the Mount B. Thank you so much.
Thank you very much, Sweden. So the question, it is a hypothetical one. So no decision has been taken yet, of course, in any regard that whoever is going to work definitively towards such a cooperative database, it is to prompt the consideration that would have to be taken into account when one would want to pursue that avenue. I give the floor now to Cameron. Cameron, please.
Merci, Monsieur le Président, de nous passer la parole. Sur cette question importante, je voudrais déjà me réjouir de voir que la proposition que nous avons formulée hier quand nous discutions sur les mesures de prévention des différends qui pourraient naître donc de l'application ou de l'interprétation de la convention cadre et du protocole et en lien avec la problématique des prix de transfert, nous pensions qu'il était important de commencer à réfléchir à la mise en place d'une base de données de comparable en matière de prix de transfert, une base de données qui soit intergouvernementale. Pourquoi? Parce que l'Algérie l'a relevé tout à l'heure, au niveau des pays en développement, l'accès aux bases de données de comparables des prix de transfert est un défi réel en raison de leurs coûts qui sont très exorbitants. Or, nous pensons que des informations sont des données qui sont disponibles, qui sont à la portée des administrations fiscales. Donc, nous pensons qu'on peut, dans le cadre de cette discussion que nous avons ici, et dans l'optique donc de renforcer cette coopération entre les administrations fiscales, on peut donc essayer de réfléchir à trouver le moyen de mettre en place une base de données intergouvernementale. Chaque juridiction pourrait donc collecter les données à son niveau et contribuer à une base de données qui pourrait donc être partagée à l'échelle de toutes les juridictions. Cela permettrait donc de mieux adresser les problématiques de prix de transfert et donc en conséquence de limiter les risques de différends et de contentieux. Merci.
So I'm trying to understand the issue better. So is it, in your experience or perception, that access to information, relevant information, is lacking altogether, or is it that for a subset of, for example, cooperation, data are not available? So is it that you would say, well, when it comes to the very large entities, data are fairly updated and available, while it is rather for maybe the smaller, medium-sized entities for which information are missing? Or is it like, can you say across the board, here we have deficiencies? So maybe keep that in mind. So that is kind of an additional question you can consider when answering those questions. So Brazil, please.
Thank you, Chair. Well, a few points. So I think the question raised by Austria, if I understood it correctly, why amount B has not been picked up. I think it is because the solution in the end was not that attractive. So it's always the details. The idea seems to be good, but as it turns out, apparently the margins that were put there, they're not very attractive. That's what I know. And I don't know much about it. I might be wrong. Second point is the idea of we designing or the UN designing a database. I am not sure. Well, we could transform it into a public good, but I'm a bit skeptical that it can be done with efficiency and the precision that we might need. A different approach could be to work with the companies to see what they want, if the governments can supply more information to improve the database, and even that, I think there would be several difficulties in sharing information with companies. In relation to the cost of the databases, one approach could be countries together to buy them or to negotiate the database together, try to make a pool, and again, try to address it through coordination, regional coordination. And finally, I think the most important intervention is, this is an extremely technical topic, and I would strongly advise to interact with the group of experts in transfer pricing at the UN, and even maybe in other fora, to get their feedback. They probably have much more to say about it than us. It's just I understand that it's just a first step, a first round of discussions, but we do need to coordinate with them. Thank you.
Thank you very much, Brazil, also for flagging the necessity to cooperate with other experts fora. So that has been mentioned now several times. And all our work will be conducted based on the terms of reference in which paragraph 22 encourages us to seek out or seek the input from other fora and not to like reinvent the wheel. Nigeria, please, Nigeria.
Thanks, Co-Chair, and good morning, colleagues. Regarding the comparable database, it is true that we have commercial databases, and from there you could obtain information. And the issue of cost is an important factor that has limited many African or developing countries from having access to the database. So that is one issue, as already highlighted by speakers who are taking the floor before me. There is also the challenge of the databases that I know of that we have do not have information, let's say sufficient information from our own region. So if you finish or you are doing your transfer pricing analysis, you look for comparable data sets, and you are getting from other regions where your economic indices are not exactly the same. That leads to another problem of you need now to make comparable adjustments, and based on transfer pricing rules, the more adjustment you are making, the more far away you are going from the reality, and more disputes could emerge. So these are other issues that causes disputes. And most of them could even be a domestic issue, really, because if you have two sets of comparable and you are dealing just with domestic transactions, that is, you're not with a treaty jurisdiction now, you could find a way to resolve that. But if you are dealing with a company or a multinational from a treaty partner, then their head office weigh in, and there could be another challenge. I am using, for example, comparable data sets based on subscription to company A, and they are using that of company B. You do not have any rule that says everybody must use A or you must use B. So from experience, the set of data in these commercial databases are not exactly the same. So there's also variation there. That's the point I'm trying to make. So somebody uses A and somebody uses B, you now want to try and match it. So it leads you to another level of dispute. So if you now look at the proposal, UN, what they're considering the possibility of developing a database, it could solve that problem. So it could bring about a kind of uniformity in that. So if we are using the same set of data, then it limits issues of dispute because we are speaking like to like now. Then how would that then address the issue of cost? We must also consider it. Is it going to be cheaper than what you have that many jurisdictions are not able to subscribe to, or is it going to be absolutely free? That's another consideration. Then the issue of the data daring. Will it be possible? We must develop something if that is the route we want to go. Develop something that data from all the regions are contained therein. So that solves the problem of having to make comparability adjustments. On the question around confidentiality, how do you preserve that? I am not foreseeing any serious challenge therein because the current versions of databases that we have in the public domain were done by businesses. And if they could summon that challenge, because with what I know, the information contained in those databases are publicly available information. So if that is the case, then it shouldn't be a problem with the United Nations having that kind of database for members. On Amon B, I think Brazil has hit the nail on the head. It is not attractive to many African countries. For us in Nigeria, what we have done is to have conducted our own impact assessment, and we believe that we are better off without Amambi than if we signed on to Amambi. Thank you.
Yeah, thank you very much, Nigeria. So I think that the current databases that are populated from a mix of public data, semi-public, but also stemming from commercial sources, and with a view to the fact of like conflicting data that also must have like root causes for that. So I think the databases can eventually only be as good as the sources that are being used to populate the databases. Next is Saudi Arabia.
Thank you, Chair and Co-Chair, and good morning. I think if I start with the first issue about the procedural matters when it comes to dispute resolution, I think one of the challenge, maybe as we also highlighted yesterday, which is the timely response of the competent authorities and the taxpayers to request for information. I think this matter is important because delay in providing the information would definitely delay the dispute resolution process and will be more costly to tax administrations and also the taxpayers. And I think the second point also is to share complete set of information as requested. This is also another challenge, that when you make a request for a specific information, you got incomplete set of information that doesn't help in moving on with the dispute resolution process. So I think these two are procedural elements that should be considered going forward. I think when it comes to the issue of the database, I think this is a very, very well-known issues of lack of local comparables. And I think, as we all know, these comparables lack location-specific advantages. You know, markets are different, cost of doing business are different, and that's not reflected in these comparables that are available. I'm not sure whether the UN should develop its own database or rather encourage the development of regional database in different regions, because as we know, the majority of databases available today are commercial databases. And also maybe another thing to be considered is maybe market-specific adjustments for these foreign comparables to make sure it reflects the reality and profitability of these markets where there are no comparables. Thank you.
Thank you, Saudi Arabia. The floor goes now to Estonia.
Thank you. Again, first a disclaimer that it's not really my area of expertise here, but I thought I would share some sentiments that we usually have in Estonia, where the issue of centralized databases comes up. We would, in general, try to avoid such technical solutions because pooling huge quantities of data to one place raises significant issues of the governance and also the cybersecurity issues. And there have to be very good safeguards in place to guarantee the credibility of such exercise. So I would now extend what I have said also to the calls for having a global assets registry or the global beneficial ownership database. First, it's a technically extremely complicated exercise, and like Michael said, the data quality is only as good as its source. And now, if we imagine that UN was to have such a transfer pricing comparables database, then when we began the work by pooling the data from different sources, then somebody would need to ensure that this data is actually comparable. And we are already struggling with, more simplified data exchanges to make the data from different sources match. And within the European Union, which is quite a small region and with a lot of experience in data exchange and highly standardized formats. So the idea sounds attractive, but because of legal and technical challenges, again, at the first glance, I would be very hesitant. And also, there is a reason why the commercial databases are that expensive, because a huge amount of work goes into it. And this work will be no less in the UN. So somebody at some point would still need to be paying for that. And also the maintenance of such a database. It's very challenging and very costly exercise. That's what I wanted to say. Thank you.
So thank you, Estonia. I'm not comfortable referring to this as an idea. Not yet. Well, okay, it was meant to take it as a Gedankenexperiment, like a thought experiment, to kind of stress that there is a balance one wants to strike between having meaningful, comprehensive data on the one hand, but at the same time have to cater for data safeguards. That has been mentioned. We have heard previously that those data are often publicly available, so therefore there shouldn't be any concerns when it comes to secrecy and any safeguards to that end. But at the same time, we are also hearing that, well, the data is maybe not is either not comprehensive, it's not very telling, is not that meaningful. There are deficiencies seen in terms of quality of the data. So, and rising the quality or the comprehensiveness of the data can get in conflict with the possibility to have them publicly available. So with that, let me give me the floor now to Marlene, because she wants to add something.
No, just to agree with Michael on the issue of what we are trying to achieve. So the issue of public databases, assets, registry, and so on, those are issues that have been around for a long time. And so the intent here is to explore whether these are viable, and we have gotten input to suggest that they may not. but also so that we can try to get ideas that will bridge the gap in terms of the data asymmetry which exists. I think as long as, and I'm speaking now from the standpoint of a developing country, as long as there is that gap, and the gap could be the result of the cost of having the best databases available. It could also be a capacity issue as well, in that you do get the information through other means, whether it's from exchange of information agreements or third-party information, and but your auditors just don't know how to use that information. And the result is that there is a dispute. And so the issue that we are trying to grapple with is how do you bridge that gap? So, I'm saying all of this to say that we are just throwing these questions out just to get your feedback because of the long-standing problem that has existed. Kenya, please.
Good morning, Chair, colleagues, plenary, distinguished members. I would start by saying that the fact that we are so many participants, it can send you to forget what you're about to say, and actually you also run the risk of repeating what others have said. However, I would start by recognizing my senior from Mauritius. I think he articulated very well on the first slide that had been put there, and is my senior in all aspects. But we can still go back and just have a review of the discussion that he had put across, which he actually explained it clearly. From the Kenyan perspective, our legal system, as much as we gravitate towards common law, we are a hybrid as it is. And there is a mix in between. And so when we talk of fact-finding tools, I don't know if the Secretariat can take us back to that particular, yes. Slide. Yeah, thank you. I just wanted us to look at a few fact-finding tools that we'll be talking about within this legal system. One of them would be maybe use of documents that are reviewed and analyzed at this particular point. The other one would be maybe the witness, now the deposition of witness statements that you're talking about, or we can refer to them as interviews and statements. And then we'll also have expert opinions and reports. Then there will be the aspect of evidence collection and preservation. Then the kind of techniques, investigation techniques that would be used within that particular issue, and then the research and data analysis. So there's a point that was put across that at one particular legal system, you'll realize that what will be considered evidence in another, the other side would be hearsay, or maybe it might be admitted as a persuasive item. So we would say it might take quite a lot of fact-finding in terms of trying to bring these two together so that because of the variation of legal systems within countries, to be able to apply this kind of model that we are suggesting. Then on the second issue, we'll be talking about the commercial basis, commercial databases that we are looking at. There are two specific issues that I would like to address. One is the cost, And then the other is the quality of data that is held within the databases. The cost has been articulated very well by my colleague from Nigeria, and it is a reality in most of the countries. So if you look at the quality of data that we find in these commercial databases, you'll start realizing that you cannot address or look at the data without using statistical tools, which in itself is usually an issue. It's been queried by the courts, measures of central tendencies, the mid, median, mode, and you really have to go in and try and explain yourself for you to be understood. So as much as we might have an issue with the quality of data, also the statistical elements that you have to marry with the quality of data becomes an issue. While at it, we'll also have to address the issue of the data. Where has it been picked from? What type of economies has it, the geographical location of the particular companies? For instance, most of the time we usually rely on data from Eastern Europe. But the same has also been questioned as to whether they are comparables to that effect. So we welcome the development of data by the UN, but with a pinch of salt, because of the issues that have been raised by a number of countries in terms of whether we'll be able to get the correct data that would address the issues that we are facing with precision, and then also the element of cost to that effect. Then on the other issue of amount B, that is baseline marketing and distribution, it is something that is still under discussion, and currently we are doing an impact assessment. But the question has always been, there are services that we can look at them as baseline, but depending on how they are performed, they have the ability to actually create intangibles in themselves within a particular territory. So that has always been an issue. However, it's something that we're still looking at, and we will be doing it and getting a report from the same and then take a position from there. Thank you very much.
Sweden, please.
Thank you for letting me take the floor a second time. I just had a few comments on what has been said here earlier. I mean, if you, in the long run, is looking for something that will be stable and also accepted by the courts, I think you can't dismiss the idea of having databases. For sure, databases, I mean, the experience from what the project we did was that, of course, it's not perfect. Of course, we had a lot of issues with the data, but at the end of the day, you have to ask yourself, what is the better option? You can say that, yeah, we can find local comparables, we can have secret comparables, but we have to think about something that will be accepted by the two states or more states actually involved in a transaction or in a transaction, where I still believe that databases is really a very good starting point, even if it's not sort of involves, for example, my jurisdiction. I would still think you can take the data from there, because I think that it's. So I just wanted to say that I mean, not believing, saying that it's not perfect and we shouldn't use it. I think that is something that I guess most transfer pricing specialists would not agree on. I think that to have the data would be extremely helpful, I think, for developing country, I think, or for many at least. the question is, how do you get there? And I also thought it was very interesting, what the delegate from Kenya said about also how they view, because the issue, if you don't believe that the margins that you have or what was done in amount B, if you don't believe that where you really, everyone could be involved, you could scrutinize all the data, etc., etc. If you don't believe that that could be used, that wasn't the services, it was of course, on distribution activities. Then is the problem, because they were really based on the existing databases. So, and I think building up something from the start would be ideal, of course, but I don't know. I don't see this solution in front of me, really, although I think that it's really something you need that would sort of hold also in between states, not to prevent disputes, and also to hold in court, as somebody mentioned. Because if you go to courts with something based on some secret comparable or local comparable, I think that might also be difficult. And if you succeed, it should also be accepted by the other state. So there has to be some kind of, common approach here, whatever that would be. Building up a database for the UN would probably take too much time, but I think what the delegate from Brazil suggested, that I think most of us are not sitting with the information here. I think it's a great idea to take it back to the people who know more about that in practice than most of us do here in this room, and then sort of see where that can take us, because I still believe that even if the data that we, for example, use in my country, based on other databases of totally different countries, is not perfect, is still for us the best that we can get, and something that at least would sort of hold in courts and hold in disputes with the other countries concerned. Thank you so much.
Thank you, Sweden, and now on to Senegal.
Merci, Madame la Présidente du groupe de travail 3. Bonjour, chers collègues. Je pense que quand nous posons des questions relatives à l'accès aux comparables, dans le cadre de ce protocole, nous sommes plutôt dans la prévention. Parce que c'est cette prévention-là qui nous permettrait d'empêcher des différends qui seraient nés de l'application de dispositions relatives en matière de prix de transfert. Et je pense que c'était utile que nous puissions d'abord donc camper notre débat. Et concernant l'accès aux comparables, je pense qu'il y a deux problèmes. On a un problème d'accès, mais aussi on a un problème de couverture de ces bases de données. Il ne faudrait pas oublier que les bases de données, quand elles ont été conçues, elles ne l'ont pas été conçues à des fins de prix de transfert. Elles ont été conçues pour des raisons d'entreprise, pour des raisons financières. Naturellement, si nous voulons aujourd'hui les utiliser en matière de prix de transfert, nous ne pourrons pas occulter les différents ajustements qui seront nécessaires. Ce qui explique d'ailleurs le faible degré de comparabilité que présentent certaines de ces bases de données. Et si vous vous rendez compte, vous allez vous rendre compte que beaucoup de ces bases de données, vous serez obligé, en tant que pays en voie de développement, de recourir des fois à plusieurs bases de données. Parce que les sources sont différentes. Les éléments les concernant ne sont pas les mêmes. Vous allez avoir des bases de données qui traitent plutôt des coûts en matière de redevances, d'autres en matière de transactions, donc d'autres en matière de brevets. Donc c'est totalement d'où déjà l'une des difficultés. Comment recourir à des bases de données totalement différentes pour régler aussi des prix de transfert qui sont épars au niveau pays. L'une des complexités aussi réside dans les différentes approches qui existent. Il n'y a pas, aussi bien dans le guide de l'OCDE relatif au prix de transfert, ainsi que dans la manuel des Nations Unies, il n'y a pas une approche détaillée qui a été mise en œuvre et portant sur la sélection et sur l'ajustement de ces bases, de ces comparables. Donc, ce qui laisse souvent déjà un certain degré de flexibilité aux États et qui potentiellement pourrait générer des différends. En termes d'alternatives, je pense qu'il serait important que les États commencent à évoluer dans la constitution de bases de données qui auraient de sources primaires, de telle sorte que toutes les déclarations qui seront générées dans leur juridiction, toutes les données à caractère financier, qui vont impliquer à la fois des transactions internes, mais aussi des transactions transfrontalières, puissent être agrégées et pouvoir évoluer déjà dans la définition d'une base de données qui probablement pourrait leur être utile à l'avenir, d'autant que les comparables internes sont les comparables les plus pertinents. Il serait aussi important d'avancer dans le développement ou la promotion des accords payables en matière de prix de transfert, surtout dans certaines transactions à faible marge ou à faible valeur ajoutée, ce qui permettrait déjà d'évoluer comme si on était dans un processus d'audit a priori en matière de prix de transfert et d'avoir accès à des données parce que vous aurez une procédure contradictoire, mais qui ne serait pas dans le cadre d'un contrôle. Et vous avez suffisamment de temps, 3 ans, pour instruire déjà un accord préalable en matière pour constituer un accord préalable en matière de prix de transfert et même recourir à l'assistance administrative en matière d'échange d'informations. Et je pense que ce sont des choses qui pourraient être intéressantes à l'avenir. La centralisation dans le cadre d'une gouvernance de ces bases de données qui se ferait au niveau des Nations Unies pourrait être intéressante dans le respect de certaines considérations, je pense, qui ont été soulevées par l'Estonie, par l'Autriche aussi, et que cela permettrait quand même de ne pas recourir à des bases de données différentes et d'avoir un seul interlocuteur, tout en prenant en compte les critères qui seront relatifs au coût, mais aussi qui sont relatifs à la mise à jour de ces banques de données. Enfin, pour le montant B, dont le principe était la rationalisation et la simplification du principe de pleine de concurrence, notamment pour les activités de commercialisation et de distribution, ça a été un bon début qui est parti des bases de données existantes, naturellement avec certains ajustements pays qui seraient requis. Il est important que les pays puissent d'abord tester pour savoir effectivement si ce montant bien pourrait leur être profitable et évoluer ensuite vers d'autres choses. Mais je pense que le montant B ne concerne qu'une partie des activités, notamment de commercialisation et de distribution. Et il y a d'autres activités qui ne sont pas incluses dans le montant B et pour lesquelles l'ajustement nécessiterait forcément des comparables. Je vous remercie.
Thank you very much, Senegal. India, please.
Thank you, Khalid. We acknowledge that information symmetry across jurisdictions poses a significant challenge for tax administrations. And in this context, building a global database of comparables is not only critical, but also a foundational step that this forum may give serious consideration to. We realize that comparables present multiple layers of complexity, both in terms of regional differences and in the nature of transactions, particularly in the case of unique or evolving digital business models. At present, there is heavy reliance on information submitted by taxpayers, such as transfer pricing documentation or TP study reports. This dependence persists even during the APA process, where the taxpayer's own disclosures form the primary evidence base. Confidentiality is frequently invoked as a ground for withholding supporting details, leaving tax administrations with limited means to independently cross-verify the information. From our experience, transfer pricing adjustments are often constrained by the non-availability of uniform data field across jurisdictions. The absence of standardized formats requires additional calibration, and this must be addressed if we are to move towards an effective global database. Further, such a database must go beyond numerical values to capture the contextual realities. For example, in the case of intangible or royalty transactions, the rate alone cannot be a sufficient basis for comparability analysis. The underlying agreement is essential to assess the true nature, scope, and applicability of the transaction. Furthermore, certain taxpayer data fields, such as those involving intangibles, payment structures, or other commercially sensitive elements, raise legitimate confidentiality concerns. And any framework for a common global database must carefully balance the goal of transparency with the need to safeguard sensitive commercial information, which may be viable potentially through secure access protocols or tiered data sharing arrangements. While building a global database of comparables may be a costly affair, it is important to recognize that countries are already incurring significant costs individually to maintain and access their own data sets. In many cases, these expenditures are recurring and fragmented, with each administration paying for access to commercial databases that may not be fully aligned with their specific policy or enforcement needs. A cumulative pooled approach could potentially optimize these costs. Even if the aggregate expense turns out to be higher, the value proposition of having a database specifically designed to serve the requirements of tax administrations, rather than being shaped by the commercial priorities of M&E-focused providers, would likely outweigh the additional cost. And such a database would also promote uniformity, improve comparability across jurisdictions, and reduce reliance on taxpayer-supplied information that is often shielded under confidentiality claims. Ultimately, the investment has the potential to strengthen global tax administration capacity and the level playing field, particularly for countries that face resource constraints when challenging well-resourced M&Es. Thank you.
Thank you very much, India. Zambia.
Thank you very much for giving me the floor. And good morning to all the distinguished delegates. So just to answer the first slide, on a general note for Zambia's legal framework is that we are a common law jurisdiction, and we do take into account witness statements as well as the affidavits in court cases, depending on the nature of the case. And the affidavit evidence usually used for non-contentious and factual matters, while the witness statements are mostly used in contentious matters. And under the common law systems, in rendering judgments or dispute resolution, rely on the law and case precedents of similar matters that could have been decided before, which now brings me to our second issue on comparables and why we think a database is very important. From experience, the issue with some of the database we've been able to pay for, the costs are already high, and when we do the analysis, you will find that it does not reflect the economic climate of the country. We discovered that you find most of the M&Es that are used are from the north, and therefore very few from the south. So already that is a disparity. Therefore, having one that would reflect the maybe common economic positions in certain regions would be important. And when I think of a database and looking that we would obviously maybe look at the precedents in similar matters, if we have one MNE from a particular jurisdiction operating in a certain region, and they're definitely recording different operating margins from the same region, and if that information is shared or accessed, it could definitely help, because then it would build a case for the other jurisdiction in that sense, in our case, because then it would be a precedence that the MNE is operating when it comes to transfer pricing. Therefore, a shared database would be cardinal. As with regards to amount B, we do appreciate and thank the work that has gone in the work, but as mentioned, I think from my earlier colleagues, there has been a feel that it does not really reflect. However, in Zambia's case, we do adopt the OECD transfer pricing guidelines, and amount B is an extension of that. Therefore, we do not inhibit any taxpayer from using amount B if they decide to use it. We haven't had any taxpayers so far apply it. So it may be too soon to say that we have not implemented it. So it would be good to see maybe in the next few years if we do have MNEs that are going to present that in their transfer pricing documentation that they're using amount B, then we could probably have a conversation in that essence. But I think it's a little bit too early, especially that it was recently concluded. But I do feel that it's important that we do have a database, because as long as information asymmetry continues to exist, multinational enterprises are still going to use that as the weakest link and use that to their advantage. There is a question that the co-lead did ask, saying, are we looking at large multinational enterprises in this case or not? With large multinational enterprises, you would find that the data is publicly available, so that makes it easier. Whereas with the medium ones to the small ones, the data might be had, and that's where the problem comes, and that's where the gap, I think, really lies, because then even if you created a database and we don't have that information, it may not be helpful. But if tax authorities work together, because this MNE is operating in your jurisdiction and you're already receiving data about its operations on the other side, that could be a basis to start and see and say, if they're in the same line of operation, its distributions, why would there be reporting different margins in the same region? I think that could be a starting point. Thank you.
Thank you very much, Zambia. Okay, I'm going to give the floor to Lesotho, and then we'll come back to Brazil and the Russian Federation, since it's the first time that Lesotho will be taking the floor. So thanks.
Thank you, and good morning. I think I just want to share experience that we have, which was basically is basically building on what Brazil indicated earlier on, that perhaps if you do it on a regional basis, it might as well help. And if you engage people who are actually very knowledgeable in this regard, it helps. The experience we have is that we've been working with ATAF, which has a very good technical assistance insofar as transfer pricing is concerned. So we're working on a number of cases whereby they were able to secure databases for us, and it was good, I must admit, and we were able to see some results. After some time, the technical assistance ran out, and we had to continue with our transfer pricing cases. Unfortunately, the price just went over the roof. In other words, we could not afford the very same database that we're using for free when we're dealing or under ATAF. So that was one aspect, the price. With regards to the other ones that we were using, or the kind of databases that we see coming from taxpayers, a lot of those have been wanting in terms of what they were initially prepared for, and the fact that we don't have they are not necessarily prepared for transfer pricing cases as Senegal and India indicated. So I think that is just one experience that we wanted to share, especially as it relates to how we can regionally cooperate and make sure that we have access to the reliable databases. One other thing that is a bit challenging for us is that ordinarily they will not come to you like any other business to sell their products. So in a way, you start first already having to compromise on some of your established procurement rules. So you have to be very smart in terms of making sure that you don't do anything untoward so that you're able to secure. And when you do actually secure some of those, you might find them, even their tax compliance could be not so good. So these are some of the challenges that we have with regards to those that we actually go out and try to secure their services. But that is the experience that I wanted to share, the one that we had at regional, which seemed to be working for most countries. Thank you.
Thank you very much, Lesotho, and craving the indulgence of Brazil and Russia again. I'm going to give the floor to Colombia.
Gracias, señora colíder. Desde nuestra experiencia en análisis de comparabilidad, pues queremos compartir que en Colombia hemos tenido la posibilidad de tener acceso a una base de datos muy completa, y cuando hace ya varios años en la administración se tomó la decisión de adquirir este contrato y tener acceso a esta base de datos, se hizo un análisis muy riguroso de el costo de la base de datos frente al monto de las operaciones que estaban siendo auditadas en ese momento y que podían estar generando erosión en las bases gravables de nuestro país. Y realmente pues la decisión era que sí era necesario tenerla, era la única forma de poder verificar los análisis que nos presentaban los contribuyentes, y el costo de la base frente a las auditorías que teníamos en curso, pues realmente sí valía la pena y se optó por tenerla desde el gobierno. Como varios delegados ya lo han mencionado y también desde nuestra experiencia podemos decir que sí hay complejidad en obtener datos de compañías comparables locales, y esto en sí no es un problema como tal de las bases de datos, sino el problema es que en el caso de Colombia por lo menos, las compañías no están obligadas a presentar reportes públicos de información completa. Pueden entregar información financiera, pero no hay reporte público de la información de las actividades, de las funciones, de los activos que tienen las compañías. Solo tenemos información de compañías colombianas que cotizan en bolsa de valores, y pues ellas sí, por esta condición, pues requieren tener un reporte público de todos sus informes. Entonces, cuando vemos esto, pues nuestra decisión es tenemos que tomar comparables de otras regiones. Sin embargo, pues sabemos que esto tiene que estar sujeto a los ajustes a que haya lugar, pero en todo caso, pues nunca vamos a tener una comparabilidad perfecta con compañías exactamente iguales, así que es lo que pues debemos hacer técnicamente. Lo otro es que en cuanto a las asimetrías que se pueden tener entre la información que reportan los contribuyentes de las compañías comparables seleccionadas y la información que puede tener la administración tributaria desde su base de datos, en el caso de tenerla, pues es muy fácil verificar los informes y reportes públicos que tienen estas compañías para verificar estas diferencias. Finalmente, las bases de datos lo que hacen es recoger toda la información pública que tienen las compañías a nivel mundial. No hay otra forma de obtenerla. Y con todo esto, pues no vemos viable por eso que Naciones Unidas tuviese que entrar en un costo tan alto de desarrollar una base de datos cuando pues ya hay unas existentes, porque seguramente sí es muy costoso y como lo han dicho otros delegados, va a requerir un mantenimiento, va a requerir una actualización y los ajustes que se deban. Entonces sí compartimos lo que también decía Brasil, de ver la posibilidad de pronto más bien tener un apoyo, una cooperación entre los países que permita tener acceso a estas bases de datos. Y por último decir que para nosotros y desde nuestra experiencia sí el fortalecimiento de capacidades en precios de transferencia es vital. Por lo menos en Colombia marcó la diferencia. Nosotros tuvimos varios programas con organismos internacionales y porque no es solo obtener información y obtener datos de bases de datos, es realmente saber cómo hacer una verificación y una auditoría a una operación en precios de transferencia, que finalmente el análisis de comparabilidad es lo último a lo que debemos llegar. Lo más importante es conocer la transacción, conocer las empresas, conocer cómo funciona la operación entre los vinculados económicos y ahí sí pues llegar a un análisis de comparabilidad y ya pues lo que sea de ajustes estadísticos, eso pues se va aprendiendo y hace parte ya de la función que uno tiene como auditor en precios de transferencia. Muchas gracias.
Thank you very much, Colombia. All right, so we're running out of time, so we're going to take 3 more interventions from member states and then leave maybe about 10 minutes for civil society if you want to make any interventions. So we'll take Switzerland and Brazil and then Russia and then give some time for civil society. This for
Thank you.
For the stakeholders. So please go ahead, Switzerland.
Thank you, colleagues. I will start with the first question that was raised by you this morning, but I promise to be brief. The question relates to fact-finding tools we use, and in our domestic procedures, there is a clear rule for the burden of proof and facts that increased taxes typically must be proven by the authorities, by the government, and facts that reduce taxes by the taxpayer. In an international dispute, such as a mutual agreement procedure, typically there is no such rule for the burden of proof. What has crystallized is a bit in our experience that if you want to take a position that deviates from what is kind of a common experience or language or experience or from a common experience that you share, then you factually have to prove that. And there also comes the issue of data into play. And I recognize the need to have data that an authority thinks that it is viable for its economy, for its geographic particularities. Regarding the development of a database, there I see considerable difficulties, technical difficulties. They have already been raised by our colleagues. First issue is you need at the end still a source for that data, and governments are biased to some extent, and there I have I see some question marks. And the other issue is that it was already raised by the distinguished colleague from Estonia. Someone will ultimately have to pay for that. Another issue in an international dispute is the disparity of information between the parties, being the both contracting states typically. And what is important there is that the competent authorities, they share information they receive from the concerned taxpayer with each other. I think this is a best practice under the BEPS Section 14, and we apply that, and we think this is something that should be a common standard and it would be fair. Thank you very much.
Thank you very much, Switzerland. Brazil?
Thank you, Chair, for allowing me to intervene again. So I would summarize that the issue with transfer price is just not one issue. It's not only about information. There's a long list of issues, statistical issues, reliability on the data used, the possibility to confirm the information used in the database, and so to investigate how reliable they are. Even the data in the database, they are polluted or contaminated somehow for different reasons. So the companies could have a lot of intra-group transactions that are still in the database, or the shareholding participation could affect the transactions. Another issue in the database is that most of them, they were built based on public data on aggregated level. So we don't have information on transactions most of the time. We have some database, to the extent that I know, we have some database, for instance, for commodities, and then you can find transactions between unrelated parties. But then again, the issue becomes, what about the functions that other companies or trading companies could have, and how to adjust those functions so they don't use directly the values of the database. So there is much more to the debate than just the database. Even when we find the database, the reliability of data that are quite reliable between independent parties, for instance, for commodities, there are so many adjustments for functions or for quality, etc. And the databases, most of them, and for instance, for royalties, there are some databases that take information from, I think, from the US, from US companies on royalties. And there are issues with these contracts as well, because they are done between related parties. So they are not fully reliable. But most of all, for other transactions in general, the data, we don't find data for specific transactions. Then the only solution is to use the TNMM method. So we have other issues with the TNMM method. There are statistical issues, because very often the TNMM method leads to a huge range of profitability. So it would vary between 2% and 18%. So if the companies choose, if all of the points have equally reliability, then we have other issues that any of the points are good enough. So if there is anything that we can move, is probably through cooperation. And I would suggest that probably we have studies on the issues of information, and definitely replacing the companies, I think it's too challenging. I don't think that it's feasible. But maybe, as I suggested before, not only inviting the TP group of experts of the UN, but also maybe inviting the companies themselves to explain their side of the problem and to help to find a compromise solution. Maybe states can provide some information, even for the VAT purposes of information. I don't know, data that is collected for VAT purposes in domestic transactions. So my point is, there are many problems not only with the data. Even if we get reliable data, it's how we interpret it. So in the long term, probably the role of this group, or we will have to have a target group to address many of those problems in the long term. But for the moment, what we can do is to find ways to cooperate, not only with companies, but other technical groups, and even maybe the CIAT or the ATAF, to get their feedback, because they have worked a lot on it. Thank you.
Thank you, Brazil. I'm going to ask that the next three interventions, because we have to close at in the next 20 minutes, that you try to keep your intervention to at 3 minutes at most. So, Russia, please.
Поддерживаем идею создания датабазы, которую мы обсуждаем. Мы понимаем вопросы сопоставимости, вопросы функционального анализа, но в действительности в торцетном ценообразовании есть вопросы, которые гораздо проще, чем они кажутся. Это вопросы, которые касаются сырьевых товаров. Несмотря на то, что сырьевые товары тоже подвержены изменениям в качестве и так далее, тем не менее, в зависимости от отрасли, есть достаточно проверенные источники, публичные, такие как биржевые данные. которые можно использовать. Кроме того, к ним могут применяться довольно понятный набор корректировок на транспортное плечо и так далее. Это может стать хорошим первым шагом, например, в создании подобной датабазы. Плюс, конечно, лучшими, более качественными данными были бы данные, которые мы получаем непосредственно от стран, от правительств. Конечно, есть вопрос поддержание этих данных в актуальном состоянии, но по поводу, скажем, силы, юридической силы или технической силы этих данных, я хочу сказать, что эти данные могут быть очень хорошей отправной точкой при обсуждении APA, соглашения Advanced Pricing Agreements. И надо в конечном счете понимать, что это вообще вопрос того, о чем страны согласятся, о том, как они определят рыночную цену при разрешении того или иного спора о трансферном ценообразовании. И такая дата-база, что очень важно, будет иметь очень серьезное значение с точки зрения развития потенциала стран, которые только начинают работать в трансфер-прайсинге. Мы знаем это из своего опыта, и мы знаем из опыта стран, которые сейчас только начинают заниматься трансферным ценообразованием, поэтому мы поддерживаем эту идею и готовы участвовать в развитии такой базы. Спасибо.
Thank you very much, Russia. And now to our stakeholders, I give the floor to Agora.
Hello. Distinguished delegates, colleagues, and friends, I speak today on behalf of Agora, an innovation lab promoting policies centered in peace, social justice, and the Sustainable Development Goals. The success of this convention hinges on its ability to deliver tangible justice, equity, and accountability for vulnerable communities. A truly transformative framework must address the specific challenges of implementation while ensuring principles of solidarity. The challenge of accessing and using transfer pricing comparable databases is a significant barrier for many jurisdictions, particularly in the Global South. The high cost of commercial databases combined with the lack of relevant data and the technical expertise required to use them places developing countries at a distinct disadvantage. To remedy this, we propose that the Convention mandates a dedicated provision for the development of an accessible non-commercial transfer prices database under the guidance of the UN. To ensure its success, we urge the inclusion of a dedicated article to formalize partnerships with institutions like the World Bank, International Monetary Fund, and the WTO to provide the technical and financial assistance necessary to build, maintain, and train member states on using the database and to build fact-finding tools and more instruments for knowledge sharing. We also propose an advisory board with representation from civil society to oversee data security protocols and ensure the database is representative of global economic contexts. These would address concerns of taxpayer confidentiality while ensuring the tool is effective and fair. Finally, separate from the issue of transfer pricing, we believe the Convention must enshrine a core principle of humanitarian solidarity. We call for a new provision that explicitly provides a tax exemption for development assistance, humanitarian aid, and official development assistance. Thank you very much.
Thank you, Agoro. I now give the floor to the ICC, and they'll be followed by the Major Group for Youth and Children, and we will close out there.
Thank you, Madam Chair. So I'll try to be very, very brief, and I'm very look forward to also engage on these topics as the work of the workstream continue, also to provide more comprehensive information from our members. And I'll try to just briefly address both slides that were presented today. So on fact-finding and more general, also in our written submission, we really emphasize the importance to have an active role of taxpayers in relation to disputes. In fact, taxpayers knows exactly their business models and the transaction and everything that needs to be taken into account from a factual basis. And so this is why we really emphasize the role of taxpayers also to be heard, and so the right to be heard. I guess this also probably raise a good point on why we need taxpayer rights in the convention as well. So yeah, in terms of fact-finding, we really believe there's going to be the necessity to include some space for the taxpayer to be able to contribute by providing facts and information that are useful to efficiently and effectively solve any dispute that might arise. On the comparables, I will reserve to provide more information as needed. But I just like to reiterate some of the concerns that have been shared by some delegates on confidentiality in the case of a shared comparable database. So indeed, that's a concern that we also share, both in terms of the data there will be forming this database, but also the governance of those. Just wanted to reflect a little bit on the fact, but again, I will reserve to send more information in detail. Some colleagues have referred to Amount B, and industry did some study on global databases in relation to Amount B in that case, and found that actually the global databases were not so mismatching information as from regional or local databases. And another emphasis I like to put in relation to developing any new database would be that it would be central to have some discussion with taxpayers on the technicalities of that and the methodology of that. As some and many actually member countries have pointed out today, there are information that the business know, that taxpayer knows, and so it would be extremely important to have transparency in relation to the methodology that will be used. Again, I know I haven't been able to give you more details, but we reserve as possible to send any written comments on this as well.
Thank you, ICC, and I now give the floor to Major Group for Youth and Children.
Thank you, Chair. I take the floor on behalf of the F50 Children and Youth constituency of the Major Group for Children and Youth. As we have been informed that there might not be an afternoon segment, Chair, please allow us to make MGCY's final statement here. We first extend our appreciation to the Bureau co-facilitators and the Secretariat's tireless work during the committee. Children and youth have delivered an unprecedented level of contributions during this segment of the INC, sending the highest number of young people to participate in any UN-led tax processes and forums. This intergenerational representation is only possible through the support from many distinguished colleagues in this room, and we express our deepest appreciations for that. Children and Youth looks forward to the next substantive segment held in Nairobi, and expresses its willingness to continue its active participation in the process. Chair, we reaffirm the fundamental axiom that the voices of children and youth must continue to be adequately represented in this committee. We hope that by the next substantive session in Nairobi, colleagues from civil society and other stakeholders will not be pushed to the end of the speakers list, but rather interspersed with member states. We also hope to see increased diversity within stakeholder participation in the INC and calls for the mandated inclusion of the 21 major groups and other stakeholders' constituencies identified by the UNGA. We highlight our fundamental belief that in the creation of an equitable and sustainable convention, no one should be left behind in creating our shared vision for a more inclusive and fairer market economy. Distinguished colleagues, Mr. Chair, the preamble of the sacrosanct United Nations Charter states, "We the people, not we the member states." Today, we the people, we the children and youth of the United Nations have determined that we will create a tax convention that leaves no one behind. We thank you.
Thank you very much. Major Group for Youth, or for Children and Youth. So I think that concludes our interventions from the floor, and we didn't get a chance to discuss the third question that we had, but this has been a very rich discussion, and we thank you all for your participation. Right. And so to continue our discussions on the issue note and the input that we have received here, we encourage our participants in Workstream 3 to attend the meetings that will be coming up, where we will be discussing this and other exciting topics as it relates to dispute prevention and resolution. I now hand the chair over to Michael.
Well, from my side, there's not much to add. I too would like to thank all of you for the numerous interventions. Those were very valuable, both yesterday and today. Together with Marlene, we are very confident that with the collective knowledge, expertise, and experience that is gathered here in the room and in the virtual rooms of the workstream, we will manage to make progress in the next weeks and months, and we honestly looking forward to continuing our cooperation with you. Thank you. Now I hand over to the real chair.
Okay, so big thanks to the two co-chairs for all their efforts, and not only these two co-chairs, and all the co-chairs who was who helped us a lot to shape these sessions and to come out in its good format and with these good discussions that took place. I think now we reach to the end of the discussions on the preliminary discussions for Workstream 3, and also to the end of the informal discussions for this for the second session. So in these 2 weeks, we concluded 2 sessions, the first session, and this is the second session. And now we are going to close the informal discussions and go for a break for 15 minutes just to set up the podium, and we will convene again in a formal mood to close the second session. Thank you, and see you in 15 minutes. Distinguished delegates, dear colleagues, the second plenary meeting of the committee is called to order. The committee will resume its consideration of agenda item 6 entitled Adoption of the Report. I invite the rapporteur to make a statement.
Thank you, Chair. It is an honor for me to provide you an update on the first and the second sessions of the Intergovernmental Negotiating Committee on the United Nations Framework Convention on International Tax Cooperation. As the committee is aware, a report on all of its substantive sessions will be prepared for adoption by the committee at its final session in 2027. A list of documents before the committee was made available on the web page of the committee. At its plenary meeting of the first session on 1st of August 2025, committee adopted without the vote, i.e. on a consensus basis, a draft decision submitted by the chair, the reference A/AC.298/CRP.16, as amended by document A/AC.298/CRP.18, on the participation of international organizations, civil society, and other relevant stakeholders. At the first meetings of the first and second sessions, the committee also elected Miss Claudia Lucia Pimentel from Brazil and Ms. Marlene Nebhard Parker, Jamaica, as vice chairs, following 2 resignations. The final report will be finalized in accordance with the practice of the United Nations for adoption at the last session, as mentioned before, in 2027, and reflect a list of the delegations that delivered statements under each agenda item, as well as the decisions taken by the committee at its substantive sessions. I would also like to remind delegations to submit the names of participants to the Secretariat via the e-delegate platform for inclusion in the list of participants. A list of participants in all substantive sessions of the committee will be released in due course. Thank you, Chair.
I thank the rapporteur. The committee has thus concluded this stage of its consideration of agenda item 6. I now give the floor to Mr. Lee, Under Secretariat General for Economic and Social Affairs. The floor is yours, Excellency.
Thank you, Mr. Chair. Excellencies, distinguished delegates, I'm honored to deliver these closing remarks at the conclusion of the first 2 sessions of the Intergovernmental Negotiating Committee. As Chair rightly described this process as ambitious and fast-moving, in this inaugural sessions, you have proven that the description is very accurate. You have laid the valid groundwork in shaping a new era of the global tax cooperation, one that is fully inclusive, responsive to a changing world, and advancing sustainable development for all member states. During these past 2 weeks, your deliberations have been intensive and substantive. You have shared diverse perspectives on the 3 topics discussed: the Framework Convention and the 2 early protocols. The Framework Convention will provide the foundation for building new paradigm for global cooperation in tax. In particular, discussions of the fair allocation of taxing rights showed a lot of common ground, although the differences remained and the hard work that is required to bridge different perspectives. Discussions of the protocol on services focused on the issues that affect many member states, in particular digital services. There was a significant agreement on one key point, that the current international tax rules do not deal adequately with the new business models. The difficult discussions, which began this week, and on forging new rules that will be future-proof. That means they are designed to cover the new types of the services in the foreseeable future. The prevention and the resolution of the tax disputes was chosen as a subject of the second early protocol. This will pave the way for more effective and fair systems, reducing costly and lengthy tax disputes, which benefits the taxpayers and the tax administrations. This will allow the officials to utilize their precious resources more effectively. It is also encouraging to know that there is a shared understanding that the protocols, which are optional, should be designed to stand alone as treaties that can be signed individually. The spirit of the partnership, built on respect, transparency, and equality, has been palpable in the rooms. The active engagement of the hundreds of the delegates, both in the plenary and in the technical work streams, has set a powerful precedent for our future work. Excellencies, dear colleagues, as the chair noted at the outset, this is a pivotal moment, yet it is just the beginning of our journey. Having completed the scoping phase, the work streams were shifted to developing concrete proposals to be presented at the plenary in Nairobi in November and in New York in February. As you embarked on this critical next stage, I wish to reaffirm that UNDESA stands ready to support you every step of this journey. On behalf of the UNDESA, I extend our deepest gratitude to all member states for your constructive engagement. I extend a special thanks to our chair, Mr. Ramin Youssef, for your exceptional leadership and to the co-leads of their dedicated efforts. I'd also deeply appreciate the vital contributions from our partners in international organizations, civil society, academia, and the private sector. Thank you.
I thank the Undersecretariat General. Thank you. Now I'm going to give my closing remarks. Excellencies, distinguished delegates, dear colleagues, as we conclude the first and second sessions of the Intergovernmental Negotiating Committee on the Framework Convention on International Tax Cooperation, I want to express my heartfelt appreciation to each of you, member states and the stakeholders, for the dedication, thoughtfulness, and the cooperative spirit you have brought to the table over these past 2 weeks. From the outset, we understood the scale of our ambition to lay the foundation for a new era of global tax cooperation through this framework convention and its early protocols. What we have achieved together in these sessions is testament to the ambition transformed into action through deep technical dialogue, constructive debate, and a genuine willingness to find a common ground. We have reaffirmed that inclusivity is not just a principle we aspire to. It is the reality of how we work. Every member state has had the opportunity to shape the work streams, and every voice from government, civil society, private sector, and academia has added depth and perspective to our shared understanding. Our discussions on the Framework Convention, Protocol 1 and Protocol 2 have been substantive, forward-looking, and grounded in a shared vision to build a fairer, more inclusive, more effective, and future-proof system of international tax cooperation that truly leaves no one behind. As we look ahead to the third session in Nairobi, I want to remind you that the committee's work stream will continue to meet. These meetings remain open to all member states and offer valuable opportunities to help shape the Framework Convention and its protocols. This intersessional period will be important to refine ideas and building consensus around the deliverables and preliminary proposals that will be presented to the committee's plenary in November. I encourage all delegations to stay engaged and to continue contributing to this work. For stakeholders wishing to participate in the third session and in subsequent sessions, the accreditation window will be open from 20 August to 5th of September. You can find more information about the accreditation process on the website or contact the Secretariat at inc-tax@un.org. Before we adjourn, I want to extend my sincere thanks to our co-leads for their steady leadership and to all the delegation for their truest contribution, and to the UN Secretariat for their outstanding support, often behind the scenes and beyond regular hours. Your commitment has been instrumental to the success of these sessions. Excellencies and colleagues, thank you once again for your hard work, your trust in this process, and your commitment to our shared vision. I wish you all safe travels and look forward to continue this important work together in the months ahead. We will reconvene in November for the third session of the committee in Nairobi, and I very much looking forward to seeing you all there as we carry this momentum forward. Thank you all. I declare closed the second session of the Intergovernmental Negotiating Committee on the United Nations Framework Convention on International Tax Cooperation. The meeting is adjourned.